Sometimes vehicles depreciate 20% the minute you drive them off the lot just because they're not brand new anymore. And that's not something that we can get back. What we can get back is the accelerated depreciation, that extra value that vehicle has depreciated due to this ongoing manufacturing defect. Hi, I'm Emma.
And I'm Courtney, and this is Lemon Law Unpeeled, the Lemon Law podcast. Today, we're going to be talking about the purpose of lemon law and how it works, and different things you can do if you think that you suspect your vehicle might be a lemon to best protect your case. So what we're going to start with is the primary purpose of lemon law. So Courtney, I'll let you kick it off just talking about what is the overreaching goal of lemon law, how does it protect consumers, and what's its whole, vibe.
Sure. Well, I think we all probably assume the primary goal is get unsafe vehicles off the road. If you have a vehicle that has a manufacturing defect that can't be repaired in a reasonable amount of time or a reasonable number of attempts, the goal is to get you out of that vehicle, get you into a safe vehicle, or like we've talked about in past episodes, there's a sister law, breach of warranty, which may not get you into a new vehicle, but will get you cash damages to make up for any loss that you might have experienced as a result of those ongoing problems.
Right. And what differentiates the lemon laws and breach of warranty laws from other consumer protection laws is the way that it's set up. So unlike other laws, lemon law and breach of warranty actually have a section within them in which attorney's fees are taken care of by the vehicle's manufacturer if you're successful. So a lot of clients who call in want to know what percentage we get, or if we have to get a retainer, or how all of this works. And when they were drafting the lemon laws and breach of warranty laws, they understood that basically your damages are pretty much capped at the price of a vehicle, right? Because the most you can get back is the purchase price. So if we had attorneys operating off of a contingency fee for that, it'd be really difficult to be able to maintain a business when you're only getting those percentages. So with that in mind, when they drafted the laws, they put in a caveat in there that said if the consumer prevails, the manufacturer is responsible for attorney's fees and costs, because they wanted to make sure that consumers were able to find attorneys who could represent them in these cases. And that's just a huge difference, and what really separates these consumer protection laws from others in that they have that caveat.
Yeah, exactly, Emma. And so for a consumer to not have to worry about paying their attorney and have to worry about those legal fees, it's one less thing for them to have to think about when they're trying to build a lemon law or a breach of warranty case, because they want to be instead focused on building that case through repair invoices, getting the vehicle back to the dealership as many times as you can. A lot of times people say to us, well, I've already been back a couple of times. I'm just so frustrated. I just had a client the other day who said, you know what? I just took the car and I just parked it. I'm just done with it. But we always encourage people, don't do that. What you want to do is you want to get as many repair invoices as you can. The more times that vehicle is subject to repair, the greater our chances are of getting that vehicle bought back. Or if we're talking about cash damages, the greater amount of cash that we'll be able to get. So that's really how you want to start building the case, is through those repair invoices. Build them up. And at the same time, give us a call, or give whatever lemon law attorney you'd like to use a call, because both can happen simultaneously. You can get signed up, you can get the ball rolling with a claim started, and continue to go back to the dealership at the same time.
Yeah, the first step in any lemon law claim is definitely visits to the dealer. Get the car into the dealership, start documenting your visits, start documenting the problem, because that is our evidence. That's the most important piece, because the underlying theme that binds both lemon law and breach of warranty is multiple visits to the dealership for the same issue. Like, that's the main piece of this whole thing. So you've got to keep going back, and you have to keep getting them documented. I have clients that say, oh, I called, they told me to keep driving it, see if it goes away. Or, they couldn't get me in for 2 weeks, or they couldn't get me a loaner, so I didn't bring it in. Unfortunately, you can't let those types of things get in your way. Book the appointment, set it in advance, get friends or family members to help you, because loaners are not a guaranteed thing. They don't have to provide you with one. The warranty does not say that a loaner will be provided when your vehicle's in for repair. It just says that they'll repair or replace defective components in your vehicle. So you can't put your case on hold waiting for a loaner. It actually will end up being more detrimental to you than having a few days of inconvenience where you've got to rely on family and friends to help you. So I would say that is the very first step. Get into the dealer, start documenting those visits, and documenting the issue on your own as best you can, whether that be through video or other means, to try to really take note and keep the case as strong as you can. And even if it only takes 1 or 2 visits for them to fix it and you don't have a lemon law claim ultimately, at least you are ready in case that does happen. Because like Courtney said, then the next step would be to contact an attorney, or what some people do is they give notice to the manufacturer themselves of this issue and this ongoing problem. I usually recommend having an attorney assist you with that, but you can do it on your own. There's lots of information from the Attorney General's office on how to do that. Again, I think you're better suited to have an attorney guide you, but that would be the next step. So once you have, I would say at least, what do you think, Courtney, 2 to 3 visits, then you want to really start stepping things up.
Yeah, absolutely. I would say 2 to 3 because, as I had mentioned before, you can keep getting them and you should keep getting them as the process unfolds. Typically, once a claim is filed, it's usually a good 60 days before we hear back, sometimes as early as 30, but usually 60, sometimes even 90. So there's going to be a lot of time there to continue to subject the vehicle to repair. So you want to go ahead, get the ball rolling. But I always have people say to me, well, I started the claim, so I can just kind of sit back now, right? But no, you want to keep those repair invoices fresh. Not only is it important to have as many as we possibly can, but you want to have recent ones, especially if we are arguing that there is still a problem there. Again, I was talking to a client yesterday who was claiming that the problem was still there, but he hadn't been back to the dealership since the summertime. It had been about 6 months. And I was trying to explain how once we're in front of a judge, if we're in a court, if we're at an arbitration, it becomes near impossible for us to practically argue that that problem is still there if we don't have a new, fresh repair invoice. So you definitely want to keep getting those invoices even after you've provided notice to the manufacturer or we have filed a claim, which actually kind of brings up another good point. Sometimes people wonder, well, if I bring this claim or if I institute this lemon law claim, will the dealership still service my vehicle? Am I going to be blacklisted? Not at all. First of all, the claim is against the manufacturer, not against the dealership. A lot of times it's actually the dealership that suggests to our clients to go ahead and file a lemon law claim. But even if it's not, they are still under an obligation to accept your vehicle, to continue to look at it. So it is not at all a situation where, well, I've started a claim and now they're not going to fix my vehicle anymore.
Right. And we have had, every once in a while, every once in a blue moon, I do get a client that calls and said, hey, the dealership found out I have a lawyer and they won't touch my car because of that. And it's very rare that that happens. But what we do is we reach out to the manufacturer and say, hey, this dealership is giving our client trouble getting repairs. Can you reach out to them and tell them that they are to continue to service this vehicle as they normally would, even though they have an attorney? And they do. They reach out, they tell them, hey, knock it off. This doesn't involve you. Just keep fixing the vehicle as you're supposed to and let us handle it. So, and a lot of clients too ask the question of, will the loaner, if they happen to be the loaner, is this loaner going to be taken from me? And while we can't guarantee that it won't, it usually doesn't, because again, it doesn't involve the dealership, just the vehicle's manufacturer. So they usually, like you said, they're not involved and they'll just keep going business as usual with this all going on in the background. So those are the general steps for the lemon law process, I would say, is what we talked about. Get your repairs. When you reach 2 or 3, I would reach out to an attorney, have them send that notice to the manufacturer, letting them know they represent you and you have a potential lemon law claim, because then the next steps kind of naturally follow in terms of hopefully being able to come to some sort of settlement agreement or getting started in litigation if you have to. Because if you can't reach a settlement and you have a strong case, then unfortunately that is the next step. And like Courtney said, if you're able to resolve it in that sort of settlement stage after we send that letter to the manufacturer, we just start talking with them, you're looking at anywhere from I would say 45 to 90 day process. There is one manufacturer that takes a little bit longer than others, but that's the general timeline. And then you can be done. But if you're going to litigation, right, Courtney, you're looking at what do you think? 6 months to a year, maybe, sometimes a little bit more than that, depending on where you are.
Yeah, that's usually what I tell people is 6 months to a year. If we end up going all the way to trial, that could easily be a year and a half, but, I could count on one hand how many times we've actually had to fully try a case. Generally, they do resolve at the arbitration stage. So yeah, about 6 months to a year. And so it's just of the utmost importance to continue to keep those repair invoices fresh, especially if we're arguing that the problem still exists. What the court wants to see is that you have continually tried to have that vehicle repaired. And there's no black and white line there. A lot of times people say to me, well, don't I have enough? And that's a really hard question to answer because it's like, we might still be able to recover, but will we have a better chance with more? Yes. If we're talking about cash, will we be talking about more money? Yes. So there really is no black and white hard line enough. It's really all just a sliding scale of strength.
And what's tough is that as the issue is still ongoing, because a lot of consumers ask, okay, I don't qualify for the Lemon Law, right? I can't get it repurchased or replaced, but I can get cash and that's all well and good, but I still have my problem. So what can the law do for me in that situation? And unfortunately, there's a big hole. There's a gaping hole in the law in that you either have a Lemon Law claim and can get the vehicle repurchased or replaced, or you can just get cash. It's not ideal, but it's better to have something rather than nothing. But there is sort of this vacancy in terms of we can't force them to fix your problem, unfortunately.
Yeah, and that's something that we run into all the time. People say, all right, well, it's great that I have several $1,000s in my pocket, but I'm still left with this defective vehicle. So there's a couple things that practically people can do. I've had clients take the money and go to an independent repair facility. The dealership wasn't able to fix it. Sometimes they're like, hey, John Smith down there, he knows what to do. And so they'll take that money and put it toward or use it to pay for a repair at an independent facility and still have some left over. Sometimes people will just continue going to the dealership. You can use the money or a portion of the money to purchase an extended warranty to cover you even after your warranty expires. Sometimes it's a small issue and people just kind of live with it. And sometimes people are even happy to have that money and have that issue. Hey, I'd rather have this little radio glitch and have several $1,000s in my pocket than not have either. And probably the most common thing, though, what people do is they'll trade out of the vehicle, put the money toward offsetting any losses that they might experience. Sometimes there will still be losses there because they're going to get that hit for the natural depreciation. And that's a conversation we have to have a lot. The natural depreciation versus the accelerated depreciation. So the natural depreciation is how much any vehicle depreciates over time. Sometimes vehicles depreciate 20% the minute you drive them off the lot just because they're not brand new anymore. And that's not something that we can get back. What we can get back is the accelerated depreciation, that extra value that vehicle has depreciated due to this ongoing manufacturing defect. So if you get back that accelerated depreciation, but you sell the vehicle, sure, you might still be taking the hit for the natural depreciation. And that's a lot of times where that hole comes into play, where people are still taking a hit. But unfortunately, there's just nothing we can do about that. Bright side is it might get you into a new vehicle. So although you are kind of taking a hit, you're now going to have a newer, more expensive, more valuable vehicle. But that's generally what most people will do. We'll just trade out of it and put that money toward offsetting any losses that they might experience.
Right. And it is difficult, but as I say to clients, we may not be able to make your situation perfect, but we're making it better than it is. Because right now you're driving a vehicle that's not functioning properly, making your monthly payments, and you've got nothing back because of it. So at least you get some sort of recourse, some of your money back, as opposed to just continuing on the way that you are. And a lot of times this can become difficult too when the manufacturer is saying, hey, there's nothing wrong with this vehicle, but the client is insisting that the transmission hesitates or bumps or lurches. And that can be really tough too with these cases when we're arguing over whether there's even a problem. Or maybe they'll acknowledge it on one repair order and do a software update. And then after that, they say everything's normal. That can make things really tricky. And a lot of clients turn to online forums and will send me, hey, all of these people are having the same issue, or this is the repair that they recommended. How can we make the manufacturer do this? And unfortunately, we still can't. And like Courtney said, so in this situation, you can try to get cash and have that repair done by an outside facility instead. It's just those forums and that information is not admissible evidence. So we can't bring that stuff into court because we don't know who wrote it. We don't know who's behind it. We don't have that information. It's just an online posting. So that can be really frustrating sometimes for consumers too, when they're validated online and that so many other people are experiencing this, but the dealership is saying, either they're saying it's normal or according to some bulletin from the manufacturer, that's just how, this happens often with transmissions, which is why I keep going back to that, but that's just how this transmission functions. And that can be really difficult. And that, again, brings us back to why it's so important to continue to bring the vehicle back, especially if the problem's getting worse. Because when it's really intermittent, it can be hard to diagnose, but the more frequently it happens, then you have a greater chance of them being able to duplicate the issue than not. And sometimes you can also ask to test drive the vehicle with a technician if you're comfortable with that, to see if you can show them what's happening with your vehicle to help assist in getting that repair. Because again, those documents, that record keeping is really, really important for your claim. And on that same token, as much as you bring it into the dealer, you advocate for yourself, sometimes the repair orders don't totally accurately reflect what happened on that visit, or they don't properly describe the issue that you told them that you were having. And that can be tricky too, in terms of what are the responsibilities of the dealership and the manufacturer when it comes to these types of issues and these visits. So, Courtney, I'll let you maybe explain a little bit about how the dealerships are involved or not involved in this process and things that consumers can try to do to help strengthen these repair orders.
Yeah, so the claim is against the manufacturer, not the dealership. But the dealership is really who you're working with, right? You don't go to the manufacturer's headquarters. You really have to take the dealership's word as truth. So it can be really tough when the dealership is saying, oh, that's just how it operates, because you are expected to accept that. But like you said, one of the things you can do is you can ask to test drive with the tech or a supervisor there. Sometimes that can be really helpful, especially for issues that are a little tough to disclose. Maybe it only happens when I'm going around a turn and stopping or accelerating quite like this. It can be really helpful to test drive with one of them. A lot of times people also don't realize you can ask them to keep your vehicle overnight. So a lot of times there's issues that are only going to happen on cold start. Communicate with the dealership. Say, look, this only happens when I first start the vehicle in the morning. So by the time I get here, it's no longer happening. Can you keep it overnight? That way one of your guys can go out and drive it first thing in the morning. Another thing that I've seen happen, sometimes the clients don't like this, so it has to be something you're comfortable with, is the techs will actually take the vehicle home with them for a week, even drive it to and from work for a week or so. And that can be really helpful with these really intermittent issues that are only coming up every once in a while, because that way the vehicle's being driven a whole lot more than just that typical 5 or 10 mile test drive while it's sitting at the dealership. So again, if you're comfortable with that, might be another question, but if you are, that can be a good resource. But yeah, work with the dealership, communicate with them. Sometimes it can become kind of a hostile environment if you're aggravated and you're angry, and then they can kind of be angry back. So I always try to encourage our clients to work with them. They are your ally. It's no skin off their back if this vehicle is getting bought back or if the manufacturer has to pay you out in damages. So they're not your enemy. A lot of times they are able to work with you. And if you have bad blood with one dealership, try a different one. Your warranty is good at any authorized dealership. And so a lot of times it's really helpful actually to go to a new one. Not only will it be a fresh set of eyes, a fresh set of techs. Sometimes if one dealership's techs can't duplicate your issue or can't fix it, sometimes another set of people will be able to. And it's also just fresh people that perhaps you don't have that animosity and frustration built up with already.
And I usually recommend, if you are going to try another dealer, don't call them with this whole story of what's been going on with this other dealer. They're not helping you. They keep telling you there's nothing wrong with your car. Because if these dealerships get any hint that maybe this might be a problem, you might be difficult, this might be something that they just don't want to get involved in, they will tell you, okay, since that dealership has already started the repairs, go back to them. So usually I recommend just call them, tell them the issues that you're having with the vehicle, and just leave it at that. And a lot of people say, well, can't they look up my VIN? Can't they do this or that? I mean, they can. Do they, though, all the time? Do they take the time to look up every single VIN that's coming in? Generally, they don't. So it's best to just call, explain the issue that you're having, set up an appointment, and just treat it business as usual from that point on. The dealership's role can change slightly once we start the Lemon Law process in terms of the final repair attempt notice that has to be sent out in some states. So in states like Maryland, Georgia, Ohio, and New Jersey, usually they want to see that the manufacturer was given what's called an FRA, or a final repair attempt. And that's part of that Lemon Law notice that gets sent out. And basically what it does is it gives the manufacturer one last try to fix your problem. And each Lemon Law gives them a specific amount of time. So for example, once that letter is sent out in Maryland and received by them, they've got 30 days to fix it. Other states are 7, some are 10. It all varies. But once that notice gets sent out, one of two things happens. Either the manufacturer will specifically send out what's called like a DTS, or a dealer technical specialist, somebody from the manufacturer who is, their specific role is to diagnose and fix hard problems or difficult problems. They'll send somebody out to specifically look at your car and evaluate it. Or there's other manufacturers that say, hey, we got your notice, get that vehicle to the dealer. We are ready to fix this. And then our clients show up at the dealership and they're like, what are you doing here? We didn't even know you were coming. So, and then it's kind of up to the dealership whether they have time to service it or not. And those can be kind of tricky too, in terms of what was the point of this. And it is more so to protect your claim than anything else. I mean, we have had it sometimes where they have fixed the problem on that final repair attempt, and then we, talk a cash settlement and we move on. But it's a 50-50 shot whether anything's actually going to happen and how involved the dealership or the manufacturer are going to be in this final repair attempt.
Yeah, I find more often than not, those final repair attempts, they're really just a formality. And I know sometimes they can be frustrating for our clients because they're thinking, hey, look, I've already gone back to the dealership 17 times, but I really need to go back again. And yes, for two reasons. One, it isn't the dealership techs that are looking at it during the final repair attempt. As you mentioned, it's someone being sent from the manufacturer just at the dealership. It's just taking place at the dealership because you're not going to bring your vehicle again to the manufacturer's headquarters. You're going to meet them at the dealership. So it is a different person who's looking at it. So it is something different. And secondly, it's just another step we have to take. It protects the claim. It's one less thing that they can argue in the future. Oh, hey, you never did this final repair attempt. So I usually tell people just go with the flow. If anything, it gives us another repair invoice, maybe get your oil changed while you're there. But it's just going to further protect your claim. And it's just another formality, a little hoop that we have to jump through. And then we can move on and try to settle your claim.
And these final repair attempt notices go out whether your vehicle is new, used, or leased. So most states treat them all the same when it comes to Lemon Law. They may have different sort of caveats in terms of, like, Pennsylvania, for example, used vehicles just don't qualify. End of story. But then there's other states where they do. So, because a lot of clients call in saying, should I even bother going through this process? I have a used vehicle. Can I even, Pennsylvania Attorney General's office says I don't have a Lemon Law claim. Well, there are different routes that we can take and things that we can do, even if it's leased, even if it's used, or obviously if you brought it brand new, then that does put you in a position where generally you're going to have most laws available to you to assist you with whatever issue you're having. What differentiates them in terms of whether you have a strong Lemon Law claim for a repurchase or replacement, or you're looking at just a cash payment, just depends on the type of defect that you're having. I mean, you have to have the timing of your visits and things like that too. But the main item that divides Lemon Law from breach of warranty, at least in my mind, is the type of defect that you have. So, Courtney, what are some examples of some issues that you've seen that you would consider to be, strong for Lemon Law?
Yeah, absolutely. Those issues that are leaving you stranded on the side of the road, that's always the example I give. What is leaving you stranded on the side of the highway while you're driving 65 miles an hour down? Engine issues, transmission issues, stalling, failing to start. Those are the general things, even though braking arguably is a very important aspect of driving as well. Braking and, correct me if you've seen something different. Brakes aren't generally something that we see bought back under the Lemon Law. That's usually more of a cash offer. It's usually the engine and the transmission issues that are going to get you a buyback.
Well, I agree with you. I do think it's a sliding scale, right? So what's wrong with your brakes? Are they squeaking? Because if the brakes themselves are still working, your car is still stopping, then I would say no, that wouldn't be a substantial defect. If they're just squeaking when you brake, but they're still working, that to me would be a cash payment type issue. Brakes are tricky though in general because those are sort of a maintenance item. So you kind of have to have a lot of repeated visits for that pretty close in time to be able to qualify with a braking issue as opposed to it just being normal wear and tear. But I do think it's sort of a sliding scale, and the same thing goes for transmissions, right? I mean, we have seen, and there's been class actions in relation to the Ford Focus and Fiestas from what, Courtney? I mean, 2010, 2012, all the way up to 2019. We saw these cases repeatedly, and there was a large class action in relation to them as well in California. But what I found the main difference between the Focus and Fiesta cars that I could get bought back and those that we only got a cash payment was how bad was your transmission? Is it just skipping or hesitating? For some reason, the courts decided that that's not a true substantial safety defect. Whereas, I would argue differently because when you're merging onto highways, when you're making that left-hand turn, when your transmission hesitates on you, that's terrifying. But for some reason, this is where we're at. The cases that would get bought back is when they had to confirm that they would press on the gas and the vehicle wouldn't go. The transmission actually failed to engage or would fail to change gears to the point where it was not accelerating or was not moving or it wouldn't go above 30 miles an hour or something like that, no matter how much you were punching it. That seems to be, you've got to look at it on a sliding scale in terms of what exactly is the issue that you're having. Is it more of a nuisance type thing? Is it truly impeding your driving? Or, what are we looking at here?
Yeah, absolutely. And similar to what you said with the brakes, are they squeaking but still working, or are they actually failing to stop? It's kind of analogous to the transmission. Is it hesitating and jumping and skipping, or is it actually failing to accelerate? As long as your vehicle is accelerating and braking, generally we're going to be looking more toward money, of course, with some exceptions there. But when the vehicle is actually failing to accelerate, to brake, to steer, that's generally when we can see the buybacks. So yeah, as you might guess, it is a little bit fewer and farther between. We see a whole lot more cash settlements than we do buybacks, especially when we have to really argue them. A lot of times manufacturers are willing to buy them back as goodwill. Cases that we may not be able to win a buyback in court, sometimes we are able to get them to offer one during the pre-litigation phase. But if we're talking about what's actually going to get you a buyback when we're arguing in court, it does have to be a pretty serious issue that is literally keeping you from driving from point A to point B. Not just making it a little bit nerve-wracking for you, not as enjoyable, not what you're paying for, but literally making it so that you can't drive those distances. Which is also another reason why the courts will look at mileage. Even if you have those 3 repair attempts within the 24,000 miles in New Jersey or the one before 12,000 miles in Pennsylvania, and you meet those standards, but since that time you've put 50,000 miles on the vehicle, we're most likely not going to be able to get that vehicle bought back because the court's going to say, well, you were able to use it. You've gotten your fair use out of it. The average person drives 12 to 15,000 miles a year. You drove 25,000 miles last year. So you can't sit here and argue that you haven't been able to drive it. Even if it wasn't an enjoyable use, you still were able to use it.
Right. And we're not saying it's, like we said, it's a gray area. We're not saying that if you have, your transmission skipping or hesitating, you're not going to get a buyback because we have seen it. It's just general rule of thumb. Those are harder cases than if your car's not starting or things of that nature because of a factory defect. And when you're having these issues, especially these substantial ones, and you're starting to look for an attorney to help you, what we recommend is doing your due diligence, doing your research. So you want to get on their website. You want to be able to see the attorney, see who they have working with them, see what states they cover. Do they cover your state? Look at their Google reviews and give them a call. Talk to them. See how comfortable you feel with them. I think that that's sort of the main kicker. And Courtney, you can obviously give your input too on what you would recommend. But I think it mainly comes down to, who are you comfortable with? Who do you feel like heard you and listened to what you were saying, as opposed to you calling in and just talking and they're just sending you a representation agreement and not really giving the time or attention to your story and what you're saying as you think they should be.
Yeah, absolutely. And you want to make sure that you can speak with one of the attorneys in the office. You're not just speaking with an intake person or with a paralegal. And while they are brilliant at what they do, and I certainly couldn't do my job without them, there is a difference. And you want to make sure that it's really an attorney who's going to be looking and settling your claim, because they're the ones who have the experience in court. So they're the ones who are better able to tell you how to build that case. Hey, look, I was in court for the same issue last month, and this is the reason we fell short, and this is what I learned from it. So this is what I want you to do differently. It's the attorney who's going to be able to tell you that. So I would really make sure that you can speak directly with an attorney if you have questions, or if you want to try to build your case. Make sure that they're available for you and can help talk you through the process.
Right. And I mean, at our firm, attorneys can't do everything, right? We have an intake team. We have a group is specifically there to listen to your case and establish whether you have a viable claim, and then it moves to the attorney. Obviously, we're happy to reach out and talk to anybody who wants to speak to the attorney first, but they can't always do everything. So I would just, talk to the intake specialist or whomever it is that you are talking to, ask them about the process. How knowledgeable are they? How well do they understand what you're going through and what your claim is? And how much can they tell you about the process? Obviously, they're not attorneys. They can't tell you everything. But I honestly just sort of think it all comes back to comfort. Who are you comfortable with? Who do you think really listened to you? And also lean on the Google reviews. I mean, they're there for a reason. And you'll be able to see on there what prior clients think of the law firm and what they may or may want to see in the future if they ever have to bring the claim again, like more communication or being told something up front that they weren't told before. These are all things that can kind of help you with your research in terms of, what should I be asking? What should I be looking for? And what are former clients saying about this law firm, so that I can be my best advocate and pick someone that I am the most comfortable with. Because it's really important to have somebody that knows what they're doing, because each state really does vary in what's required of you to have a valid claim. So, for example, Georgia is really strict. Georgia is very strict on when your notice is sent. There's strict statute of limitations that you have to follow. And there are strict guidelines in terms of where you go to push your lemon law case, in terms of you have to go in front of the Attorney General's office, or can you take it to the civil court? And every single one is different. So I would be sure to go online and see and make sure that that law firm has all the states in which you are looking for, so you know that they know what they're talking about, because these state variations really vary from state to state. And additionally, even the way that vehicles are bought back under these states can be a little bit different. A main thing being, most states say that the vehicle can be repurchased or replaced if you have a lemon law claim. And Courtney, I'll let you talk a little bit about what is a replacement, what's required of the consumer in a replacement, and when are they able to use that as a remedy.
Yeah, so the replacements versus the repurchases are something that we've talked a lot about with our clients recently, because generally we're able to see repurchases, not replacements. Years ago, we would see more replacements. A lot of times it was at the consumer's election. Would you rather have a new vehicle, or would you rather just have your money back? And it was kind of split. Who would rather have what? Are you distrustful of that manufacturer now and you'd rather just have your money and go somewhere else? Or do you want a new vehicle? Currently, the last few years since COVID, with such the national car shortage that's going on recently, it has been a lot harder to get the replacements. And one of the big reasons is the dealerships are just selling these vehicles out from underneath us before we're able to get them the replacement finalized, because it does take a while. So you have to have the vehicle secured there, and then you need the dealership to hold on to it for 6 or 8 weeks or however long it's going to take to push this replacement through. And a lot of times the dealerships just aren't willing to do that. They're going to make more money by selling that vehicle to someone new, maybe at a higher interest rate or whatever it might be. And so they're just not willing to hold on to these vehicles to get the replacement done. You also need to talk with your bank and make sure that they'd be willing to do that substitution of collateral for the replacement. You have to swap out your collateral. You're swapping one vehicle for another. And not every bank is willing to do that. So even though a lot of times people would rather see the replacement, maybe because they had a great financing interest rate in the past and they want to keep that, we're not always able to make that happen, especially in recent years. So generally, it's going to be the repurchase that we would see rather than the replacement.
Right. And it's important to know, too, that under a replacement, you have to pick a vehicle of either equal or greater MSRP. And if it is of a greater MSRP, you are responsible for paying that difference. So some clients aren't always willing to shell out that money or can't in order to facilitate the replacement, because it's not something you can finance. So because you're doing a substitution of collateral, your loan is remaining exactly the same as it was. All your payments that you had made previously and your down payment and any positive equity on a trade are all transferring to this new vehicle, and you'll go along business as usual. So they can't really change the terms of the loan. So you can't roll in an additional $3,000 to $4,000 into that loan. They need cash, basically. You have to show up with a bank check in order to facilitate that replacement. And that's just not always possible for these consumers, along with, like you said, too, being able to find a vehicle that fits the bill of what they're looking for, interior color, exterior color, features, the same model, and things like that can be really difficult. So while a replacement might seem like the easier way to go, it isn't always, because it just can be a real hassle trying to find that vehicle and get the dealership on board with helping to facilitate that. So more often than not, too, we're looking at refunds. And some clients, too, are done with the manufacturer that they're with. They don't want another car of theirs. They want to move on. They want to go somewhere different, which you absolutely can do. So under the refund, or we call it a repurchase, the repurchase of your vehicle, you will surrender your vehicle at a specific date and time that they will facilitate according to your schedule. You can't book it out like 6 months when they're calling you saying that they're ready to do it, but it's not something where you're going to be without a vehicle the next day. So usually under repurchase, we get the offer from the manufacturer saying, hey, we're willing to buy it back. And then there's a list of documents that the client usually needs to get for us in order to calculate what they're going to get back under the repurchase. We need your payoff statement, your payment history, things of that nature, so they can actually calculate everything that's gone into this. Then we'll get the offer letter once it's been, approved by their auditing department, comes to us, signed off by the client, and then the checks have to get processed. And this timing can really vary from manufacturer to manufacturer. I have some manufacturers that 30 days will be good to go. You'll be out of the vehicle. You'll have your check. And then I have others that it's a solid 90. You're looking at a solid 90 days for them to complete this process, which can be tough. And then some manufacturers give you your check right at the time that you surrender it. And then other manufacturers send it to your attorney. And then your attorney has to send that money to you. And so it's definitely something that it can be tricky to get the timing right, especially when you're going to have to get a new vehicle right after. And we do our best to sort of facilitate that as best we can for you. But it's tough. It's tough to get that timing perfect. And Courtney, I'll let you talk about too, because a huge question that we have from so many clients is, okay, I signed all these papers saying, let's say we'll use just a random date. Let's say, okay, on September 1st, I signed all of this paperwork saying this is the money I'm getting back. These are the payments I've made. But I'm not going to be surrendering this vehicle according to your timeline until November. I'm going to make 2 payments in that time frame. Am I going to get those back? I just signed paperwork saying I was only going to get X, but I'm actually going to end up putting Y in. So I'll let you sort of explain how that works and how they do get that money back.
Yeah, you're always going to get that back. And that can be very concerning, though, because like you said, you just signed off on paperwork saying you're only entitled to $23,000, but you just made 3 more payments, and now it should be entitled to $24,500. Yes, you are going to get it back. And there's kind of 2 ways that it can work depending on the manufacturer. Some manufacturers, you just set the receipt of payment, the confirmation of payment, and they're going to give it right back to you. They can add it to your check or send a separate check directly to your residence. I actually had that happen recently. Other manufacturers, it's going to come back to you from the bank. So say you had a $40,000 vehicle. You had paid $25,000 of that loan when we got you that repurchase. So you were getting $25,000 back and the bank was getting $15,000 back. But since you signed off on that paperwork, you paid an additional $5,000. Well, the bank is still getting that $15,000 check, but now they also have your $5,000. So it's the bank that has that overage, and the bank is going to give you that money back. So sometimes it's going to come back from the bank. Sometimes it's going to come directly from the manufacturer and be added to your check or be a separate check, but you are always going to get it back. I can honestly say in 15 years of litigating lemon law cases, I have never once had someone not get their extra payments back. So sometimes it might be a little concerning for a few weeks, but you are always going to get that money back.
Well, and there might be delays too, right? So, and I've had it, especially in New York, where the manufacturer is not responsible for sales tax either. I'll have to tell a client, listen, you're ultimately going to get 3 different checks. You're going to get, let's use an example where they're going to get the check at surrender. So you're going to get your check from, we'll just use the example, we'll say Ford. You're going to get your check from Ford at the time of surrender. Then we're going to submit an application to New York State to get your sales tax back. And that's going to take about 6 weeks for you to get that check back from New York State. And then any overages on your loan, any of those payments that weren't included in that check you got at surrender, that's going to come to you from your bank, usually within, I'd say, like a week or 2 of it being paid off by the manufacturer. So sometimes it is sort of like that, where you've got 3 separate checks coming to you, but it does in the end make you whole. It's just, again, is why it's important to have an attorney to be able to guide you so you know what to expect, you know what money's coming, and you know when it's coming. Because that is always, the trickiest part for all of this. And a common question that we have too from clients is, okay, how is this repurchase going to affect my credit? How is it going to affect my ability to buy another vehicle? If Jeep just bought my vehicle back, are they going to let me buy another one? Absolutely. It's not, I'll let you talk about this, Courtney, but they don't care.
Yeah, absolutely. They're willing to take your money at any point, and they'd be happy to sell you a vehicle at any point. So yes, it's not going to affect you. Sometimes people are also worried about being blacklisted from the manufacturer. You know what? I filed this lemon law claim and they bought it back from me. Is Jeep never going to want me to buy a vehicle from them again? Not at all. They don't care. Not to mention when they buy it back from you under the lemon law, they're basically saying to you, hey, we know this vehicle had some real issues. So they're not blaming you for bringing a lemon law claim against them. If anything, they're thankful that you're willing to stay with their brand. And actually, a lot of manufacturers will, along with the cash settlement or the repurchase, actually send you a secondary offer as an incentive to stay with their brand and purchase another vehicle. I actually just recently had it happen a couple of weeks ago where someone got a repurchase, and then he also got a $2,500 incentive off of another vehicle. So they're happy for you to stay with their brand. So it's not going to blacklist you against any of these manufacturers. They're always going to be happy to sell you another vehicle in the future, nor is it going to affect your credit. It's certainly not analogous to filing bankruptcy or anything like that. It's not going to adversely affect your credit.
No, it's the same as if you paid the vehicle off. That's all it is. It's just that loan is now paid off and it's off your books. And yes, they do. Some manufacturers do offer incentives. That definitely happens. Not as often as I would like it to. I'd like more manufacturers to get on that train because I feel like it's the least they could do, since clients cannot recover for pain and suffering, inconvenience. You're not going to get any of that back for what you had to go through. You're just going to get your purchase price back. So to me, it would be nice to see that, because you most likely went through quite a lot to ultimately, end up with this lemon vehicle. But it does happen. We do see it. But again, it probably should happen more frequently, than it does. And so in terms of, to wrap this up, what to do when I have a lemon, I think the long and short of all of this is to make sure you're documenting things properly, get those repair orders, get that vehicle in for repair. If one dealership can't take you, call another. You, again, as we always say, you've got to be your best advocate. And there's a lot of information online too to help you with your specific state. So, and at the time that you purchase your vehicle as well, they usually give you a lemon law notice to sign off on that details your lemon law rights. You can always also turn to your state's attorney general's office. They generally have a whole web page dedicated to it. The Better Business Bureau, or the BBB, they often also have pages specifically dedicated to describing the lemon law in your state that can be super helpful. And again, we've got our website too. We have multiple states that we work in. We have a page dedicated to those states that can assist you in determining, hey, how is it going to work for me if I live in Georgia or if I live in Pennsylvania? We have it on there too at our website, which is lemonlawcar.com. Feel free to jump on and take a look. Any inquiries, we're happy to field as well. And other than that, we want to thank you for hanging out with us today and listening to what we had to say. And we hope to see you again next time.
Thanks for listening, everybody.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary as outcomes are determined on a case-by-case basis.